Well, it's come down to this. Idaho's failure to change its abortion ban has pushed a federal lawsuit against it all the way to the U.S. Supreme Court. Tomorrow, justices will hear arguments in the United States versus Idaho and Moyle. Two consolidated cases where the Department of Justice claims that Idaho's abortion law, with exceptions only for the rape, incest, and life of the mother, violates the Emergency Medical Treatment and Labor Act. Quick recap of where it started and how it's going. Back in 2020, Idaho passed a trigger law, Senate Bill 1385, which said, should the Supreme Court overturn Roe v. Wade, a nearly 50-year-old ruling that allowed for abortion across the country, if they would overturn Roe and restore authority to the states to ban abortion, Idaho would make abortion a crime. It made performing an abortion a felony for doctors, punishable up to 5 years in prison and a permanent loss of license for more than one offense. Then in June of 2022, the U.S. Supreme Court did what many considered the impossible. They overturned Roe v. Wade with the Dobbs decision. They gave that power back to the states to decide abortion for themselves. Idaho's law was triggered, and it went into effect in August of 2022. Almost immediately, the Department of Justice filed a lawsuit because that exception, the life of the mother, wasn't enough, and it went against EMTALA. Emergency care is emergency care, and a patient should not be denied care because, well, they aren't dying yet. A federal judge immediately put an injunction in place so that wouldn't be the case. But a month later, that injunction was suspended by a 3-judge panel of the 9th Circuit Court of Appeals, said Idaho could enforce all of its abortion bans. I should say a year later, not a month later, a year later. Even this emergency care, while the lawsuit worked its way through the courts, which is what it is doing now. Because in January, the Supreme Court agreed to hear arguments in the United States versus Idaho and Moyle. And in doing so, they also agreed with the lower court ruling that the law can continue to be fully enforced. So that hearing is tomorrow. But last week, Dr. Jim Souza, the chief medical officer of St. Luke's Health System, he was on a national conference call to talk about the impact this narrow exception has meant to health care in Idaho, pointing out Idaho has lost more than 60 OB-GYNs since the ban began in August of 2022, and they haven't been replaced. Dr. Souza hopes that the Supreme Court can at least offer Idaho's doctors a lifeline when it comes to caring for patients with pregnancy complications.
Well, at first I hope they hear that the Defense of Life Act, Idaho's law, actually is clearly in conflict with EMTALA. EMTALA says that we have to act to stabilize a patient, and sometimes the stabilizing act we have to perform is to terminate a pregnancy, to stop bleeding, to stop infection, and so on. And then because of that, I hope that they will preserve this narrow injunction that Judge Windmill first put into place, recognizing that conflict. Even if they do that, though, we still have work to do here in Idaho. There are some simple fixes to the law that could be put into place that would alleviate this fear and allow physicians to practice medicine when women are having pregnancy complications.
What are those simple fixes?
I mean, the simple fix is to allow an exception for the health of the mother.
How do you feel about nothing happening this last session to fix that?
Yeah, it was very discouraging. There was a lot of trying, kind of talk about what language fixes might look like, and it all just got stopped.
The stat of how many patients have had to been transported out of Idaho to receive care.
Yes.
When it comes to maternal care.
Correct.
What is that stat?
So we've had 6 just in the first trimester, ironically, of this year.
Since January?
Since January, the first 4 months of this year, we've had 6 versus 1 in all of 2023.
That's a significant jump.
It is, and you know, if I annualize it, I tell myself we'll be at somewhere between 15 and 20 by the end of the year if things stay the same.
And this is all because that injunction was lifted?
Yeah, the lifting of that injunction has further intensified the fear amongst the attending physicians who have to manage these labor complications. What does that mean for me, and what is my confidence that I won't be Monday morning quarterbacked, second-guessed by someone, with the consequence being I lose my license and I go to jail?
What do you say to somebody who says, this doesn't happen that often? a transport, not a big deal. I guess we just have to get used to that.
Well, what I'd say is back in 2022, when the law went into effect, I remember saying, we don't know their names yet, but one day we will know their names. And their names are starting to accumulate.
What do you mean?
I mean the patients' names, the patients harmed by this.
Harmed in what way?
First, by the shock and awe that on the worst day of their life, on a day when the overwhelming majority of these patients deeply want this child and this pregnancy to be carried out to completion, on the day that they learn that that's no longer possible and you can't get treated here. So we're going to put you on a whirlybird. Or worse, I almost think this is worse. We're not sure what to do. The law prohibits us from acting at this moment, so we're going to watch you carefully and closely, and we're going to act just as soon as we can, just as soon as we feel confident that your life is in danger.
Dr. Souza said that risk to a woman's life is only amplified when they have to be airlifted to another state, when before they could just be rolled down the hall and into surgery if they need be. Something he said happened at least once a week last year in 2023 until that injunction was lifted. It's not as safe, it's costly, and it's taking away a resource from another patient who could also use it, this airlifting to other hospitals. Also, OB-GYNs leaving Idaho isn't just affecting women of childbearing age either. It comes for everybody. Oral arguments at the Supreme Court begin at 8 a.m. Mountain Time tomorrow, but don't expect a decision likely until summer.